It's like taking a number plate off a car and saying you've changed the car. You haven't changed the car and the car is still a car. That's not going to deal with pollution, is it? To put a person on the moon, you've got to think up the idea of putting a person on the moon. So what would happen in England and Wales if people no longer had a legal sex or gender? Would it help to tackle inequalities between women and men? Would it help to free people from gender norms? The current British system records sex at birth and then treats that sex and corresponding gender as a legal status. But we don't often think of sex and gender in this way. So to put it in context, nationality and marriage are legal statuses that state law registers and regulates, but our ethnicity and our sexuality aren't. Being defined as a legal status doesn't mean the law always treats people differentially because of it, as we know with marriage. But legal statuses like sex, nationality, and marital status become relevant in specific contexts, giving rise to differences in treatment that can become politically charged. Our research into the implications of dismantling the legal status of sex began in 2018, but the question of decertification, which is how we're characterizing reforms, where the state withdraws from registering and controlling how a person's sex or gender is legally recognized, was one we'd started thinking about some years earlier in response to several social and legal developments. The growing visibility of gender identities such as non-binary, agender, gender fluid, and gender queer. The growing trend towards gender neutral law and the introduction of same-sex marriage, and the establishment of formal procedures for changing one's legal sex. Now, decertification can appear as their logical conclusion, and it certainly seems the direction of travel in many countries. The rationale for treating sex and gender as part of a person's legal identity, and I should stress we're talking here about legal identity, seems doubtful, with sex and gender increasingly understood as plural, evolving, and as having no settled meaning. And there's, a vast range of ways in which both of those terms are currently understood. There isn't a consensus. Yet despite its growing incoherence, countries like Britain have retained their machinery for regulating and confirming sex and gender status. The political focus has been on bringing transgender, non-binary and gender non-conforming people within existing structures rather than dismantling the structures. But is this the right course of action? Or does it reify gender as a set of stable differences that should be treated as equally valid? And that's the kind of stance that conflicts with feminists' long-held critical account of gender as a structure of oppression. So this is what our research studied. And it was an exploration that flung us into a high conflict zone of sharply divergent opinions. In Britain, these have largely coalesced around two different stances. One argues for women's sex-based rights, the need to dismantle male domination, and an understanding of gender as stereotypical roles and assumptions. The other argues for recognition and equality for different gender-based identities and expressions, with gender being understood as something that's flexible, plural, and not defined by one's body. And some people have tried to combine aspects of both. In many ways, though, our research sits outside these two positions. Our starting point was with gender as a structural force that produces inequality. So gender is something that's generative, not just a status or an identity. And it produces inequality in terms of wealth, power, the spaces we occupy in the world, our self-esteem, and so on. This doesn't mean recognizing or treating people as pawns of gender, but it recognizes how the gendered nature of society gives rise to our experiences, status, and identities as women, as men, as trans, and so on. And that includes the meanings we give to parts of our body and our experiences of them. So our research was divided into four interconnected strands: the implications of decertification for thinking about social justice, for single-sex provision, for legislative drafting, and in terms of wider public attitudes towards reform. Over 4 years, we held focus groups and conducted over 200 interviews with public bodies, service providers, NGOs, trade unions, schools, lawyers, academics, and members of the public, with very, very different political perspectives amongst them. We also carried out a survey of public attitudes in the autumn of 2018, which generated more than 3,000 responses. The Future of Legal Gender project was deliberately speculative. We wanted people to think beyond what seems doable now, to imagine reforms not currently on the legal table. And I'll return to this at the end of this brief presentation. But first, I want to say something about the benefits and concerns that abolishing legal sex status raise. So why is it worth considering? When we talk to people about decertification, the positives usually focused on the freedom offered to those who don't fit the current binary framework of women and men. A gender fluid member of the public told us, "I would love that. I would absolutely love that." Decertification reduces the penalties and costs of living outside female and male socio-legal categories, including as non-binary, genderqueer, and agender. It also removes the need to formally transition, which is often experienced as intrusive, as pathologizing, disruptive, and controlling. But abolishing legal sex has other advantages. Being certified as female or male from birth places people in a legal status that's hierarchically ordered, socially, if not today so much legally. And certification contributes to both legitimating and socializing us into specific gender groupings that affect how we're treated by the people and institutions which continue to form us. Gender and sex are statuses that people carry with them, that are constantly named, and so constantly at work in reinforcing assumptions of difference. The ambition behind our project on decertification is to think about it in relation to producing a less gendered society. But this is a big but. The sex and gender class that we're placed in doesn't just contribute to perpetuating an unequal system, it's also used to remedy it. So we're interested, in what work can decertification do in undoing and lessening and dismantling a gendered society, but it's not a straightforward proposition. Various concerns were expressed during our research about decertification, particularly in terms of how it would harm women. Some interviewees claimed that muddying sex-based divisions between males and females would make it harder to separate women and girls in contexts of undress and vulnerability that might include domestic violence shelters, changing rooms, hospital wards, and public toilets. That it would raise problems for competitive purposes such as sports and for positive action. Some argued that decertification would produce distortions in data collection, that surveys such as the census would generate meaningless or unhelpful data if sex became subject to changing or subjective definitions in who counts as a woman or a man. And some argued that decertification would remove an important shield for those, and including trans people, whose gender is challenged, and public toilets is often the example given. And these are important concerns. The question we were trying to explore is whether a system of legal sex is required to address them, and does it address them? The work done by legal sex at the individual level is rather elusive, since it's almost never called upon. And this is sometimes taken to mean it's irrelevant, and we can discuss this later on. But from our research, the power and presence of legal sex seems perhaps more systemic and symbolic, consolidating a particular regime rather than directly determining individuals' lives. In relation to practice, many service providers we spoke with, such as for running women's domestic violence shelters, told us that they've been relying on self-identification rather than legal sex for many years. And this is work that Flora in particular was doing here. And using risk assessments and private individual spaces to manage the mix of bodies. But what about sports, data collection and positive action? Do these require people to have a legal sex so that they can be properly identified as female or male? Our research explored the problems that legal sex causes those who don't fit the categories or the normative assumptions about what women and men should be like. It also explored some of the innovative thinking that's developed of finding other ways to organise participation, such as sports. So in that context, the problems that binary categories of women and men are seen to pose has also been a prompt to some radical ideas about how else, for instance, sporting categories could be organised to achieve greater fairness and inclusion, where differently shaped bodies and different geopolitical advantages are taken into account. So this isn't an argument against women's sports, but it's also using the prompt that is posed by the complexity of sex and gender to think, well, what other issues of fairness or equality or social justice are raised when we're thinking about sports? Does decertification require that the law changes? In Britain, sex is a binary regulated legal identity that can only be officially changed through a gender recognition certificate. But many organisations have policies and practices that recognise informal gender transitioning or self-identification and other gender identities than male and female. A leisure centre manager we interviewed described how they advise their staff not to direct people to specific changing rooms based on bodily assumptions. And he said, if someone comes in and says, where are the changing rooms? We say we've got a male changing room there and a female changing room there and an accessible changing room there, and allow them to make that choice. An umbrella NGO told us, when we talk to our organisations and they're collecting data on their workforces, we say, you can't just assume something of someone. Please don't look at someone and assume that that's a male. Please don't do that. Some local councils we spoke to said they were keen to include non-binary people in their policies and practices. And one officer said, pregnant women, pregnant trans men, and pregnant non-binary people have different experiences and different needs. We can think of these bodies as practicing a soft decertification. Legal sex remains in place, but it's hollowed out as organisations act, at least in certain contexts, as if gender was flexible, plural, and self-authorised. And as if the shape that bodies take, including their relationship to reproduction, was just part of a mix of social and bodily qualities that don't necessarily gel into two stable shapes and statuses. But this approach, as I'm sure many people here in the seminar know, has faced countervailing pressure from some social activists, determined that public bodies and others apply a narrower legal language of sex. The attention given to the law by policymakers and the litigation underway over the past few years to counter policy initiatives anchored in a more expansive language of gender suggests that legislative reform may be necessary for decertification to take place, that it can't just happen through informal means. But this doesn't mean that Britain is ready for a decertification law. Legal reform doesn't have to mean a single legislative act. Decertification could be introduced over time through piecemeal policies, laws, and practices that together make legal sex status meaningless and so redundant. We might then think of decertification as slow law. Now, slow law is often used as a critical description of law, that it's taking too long and that it's behind societal values, that it's a really cumbersome, awkward, difficult machinery to use to bring about social change. But slow law can also indicate major changes that are desirable in the long term, but require other actions alongside or ahead of them. So slow law doesn't have to mean moving at a snail's pace or avoiding contentious law reform. Like slow design or slow food and other slow movements, it reprioritizes process so that rather than seeing law reform simply as a technical process that should be done as quickly as possible, it becomes the site of creative, innovative, pleasurable, participatory, and reflexive action. Decertification isn't necessarily a progressive move. It can be part of a governmental move to withdraw state attention and responsibility for gender-related harms, where gender gets read as an elective identity and structural inequality and violence are ignored. But decertification can also be part of a broader social justice programme intent on liberating people from expectations and ways of living anchored in notions of what women and men should be like. As many people told us in our research, simply removing a regulatory framework in conditions of ongoing inequality won't remedy inequality. For decertification to advance social justice, other issues also need to be addressed. And these include gender-based violence and inequality, welfare austerity, migration restrictions, penal policy, and I think also perhaps cultural attitudes towards nakedness in this country. Decertification may not depend on them being solved, but the context of its introduction matters. Decertification may seem a very modest reform or a more significant reorganising of gender in society. But what decertification also does as a slow law proposal is to invite us to think about wider change. These larger questions are part of the research process, where developing a law reform proposal doesn't simply aim to resolve a problem, but to prompt us also to reflect on parts of society and how they're organised that we've long taken for granted in critical and imaginative ways. And I'm now going to pass over to Flora Renz, who's going to talk more about our legislative framework.